Thank you. May it please the court. Yes, it is. Ms. Johnson, First Assistant Snipes, members of the jury, good morning. The English dictionary doesn't have a word for parents who've lost a child. That's something that's bounced in my head since Mr. Lane asked us to come help our friend Boyle in this case. That language, that word doesn't exist. And I know that because I've lost a brother as well. Lost him on a Labor Day about 40 years ago. He was killed in an accident. So I know from watching my parents over these last 4 decades what Mr. and Mrs. Edwards are going through. And Vidal may not see it yet today, but I know what Vidal's going through too because of how my brother passed and how those days will always be there. And we can take the sympathy, and if we were to vote just on sympathy when you went back to the jury room, Officer Oliver loses because the sympathy needs to be the majority and the Edwards family. As the court will tell you in your instructions, and that you've seen here today before you, the sympathy itself must stay. It can't go into the jury box, and it can't go into the case itself, because if it does, then this case is without its justifications or meaning. You have to leave the speculation. You have to leave all the stuff that deals with the public's sentiment, sympathy. The law requires it. Because as we go through this case and go through the case itself, this case, more than anything else, has to be rendered upon your oath. And that oath is a pretty powerful thing when you talk about a case such as this. We have Officer Gross and Officer Oliver who have stood before a higher-ranking officer at different points in their lives and sworn to protect and defend the Constitution of this state, the United States, and the other state. Defend us overseas. Combat veterans, decorated both of them. They both came back on their own paths. Officer Oliver has risen his hand once to be a firefighter, and they both rose their hand to be police officers. But the oath that's the most important one at this point is the oath we all have taken. Because you have to render the verdict based on the evidence that's before you, and nothing else. During board ire 2 months ago or so, you could tell us what you thought, and that mattered. Today, you have to take the court's charges and apply the law as you go through it. And you have to go through that and that alone. Nothing else matters at this point. You walk through it and you walk through the evidence. So as we're going through some of this evidence, and we walk through it to see how things are progressing and going through some of this stuff, we have to start first and look at the stuff. So let's go backwards to begin with. Let's talk about the ladies that were here last Friday night, right before we left. They were brought in here to stir up some passion, stir up some emotion, and show you that Roy, for some reason, is just as vigilante unhinged. And I think once you saw what happens when real questions are asked of real questions that are asked without a trip to the 11th floor of this building, without the influence of the district attorney's office, they go through and they tell you what really took place. You saw the evasiveness of the first witness, Ms. Arundado, and then you saw the sister come in. And you go through the process of asking the questions. First, you can see the weapon coming out of Roy's car, and then when you actually put the vehicles in the right positions, you can't see anything. You get to add that in. And to bring a district attorney down here, how many of you have heard in this trial, I don't understand the question? I wish they would have offered the transcript from that trial so you could understand why nobody could understand the question Officer Oliver was asked in that case. The facts in this particular case, as we go through them, must be viewed from Officer Oliver's perspective and no one else. That's what the law requires. You have to notice and walk through this as you apply these facts to the charge that you'll be given, and you'll have a copy of what the judge just read. Was it reasonable, standing in Officer Oliver's shoes on 29 April 2017, to do what he did? And you have to take into everything, all the training Officer Oliver had, all the experience he had, the situation on the ground as they knew it when they went on patrol that night. You'll recall from the testimony from Officer Gross and Oliver that there was heightened gang activity in the area at the time. They had known about that. They'd known about shots fired in the past. They get there for this party, and they put 150 plus students out on the street. While they're inside, they're talking to them. Everything's cool, calm, and collective. They're trying to be community police, do their community policing. Walk through and talk to them. Try to get the guys to understand, hey, your folks are going to be home. And y'all, when you look at the videos, if you take them back, there is furniture scattered here and everywhere. They emptied out all those rooms so they could have the party. That's not how Mom left it that night when she went to Atlanta on her trip. They're there, they're trying to get along with these kids, get everybody home safe. The shots fired. The state doesn't want to bring in what OODA loops do to people. Watch the delay it takes Gross and Oliver to react to the first shots and what they do once they recognize what's going on. Gross goes out to the right, Oliver goes back and gets his patrol rifle. Dr. Hayden, Dr. Kuntz, Captain Kuntz, every one of the officers from Dallas County Sheriff's Department testified that was reasonable and prudent. Based on their general orders, that's what they're supposed to do. Go get the next highest level to help protect the threat, help render the threat safe. We now have an active shooter situation. First Assistant Snipes will tell you it's 54 seconds in his opening statement. That 54 seconds, that brain, the computer that Officer Oliver has is taking in information, and he has to walk through it. What's reasonable from his perspective? We have shots fired. All the kids they just put in the street are now running back at them. He's watching his partner up ahead as he gets his rifle and puts the sling over his shoulder, turns the sight on, and makes sure everything's okay. We get to the point where Officer Gross calls out on the radio the first time. And then Officer Gross raises his voice on the stuff. And that's where they start saying that, I guess, Officer Oliver, if he's running at any time, it's then. It's that last 9 seconds. He's running only after Officer Gross' voice raises on the radio. His partner, as the state just said, his partner has worked a number of cases with on the streets, goes up, gets into a position as he's processing this information. But that last 9 seconds, or really that last 30 seconds there, if we're to send a message as the state's going to ask for society and what society's worth is for a police officer doing their job, then society has to take a part in living in it too. Ms. Patterson testified 2 Fridays ago. She testified along with a nice gentleman that afternoon. The gentleman stood here and picked a house with me, second house. Said he was right there in the middle of the road. Ms. Patterson picked and told us what took place. At no time did those members of the community ever step out and say, hey, it's not the car the officer's trying to stop, it's the guys that just got away. It's the guys that are down the street. They've left. You have the 2 individuals across the street, Mr. Knight and his buddy. They had well over 2 minutes to call 911. They chose not to. The officer can only process what he's given. If you're going to make that decision, you're going to say that he is not a representative of society. Society has to help in these situations. They have to provide the information to the officers. Take the video back and look at it and watch how people just carelessly walk away. If they're that far up and they're just chatting on the phone as they walk away, they had to be there when the shots came out from the nursing home. All right, they weren't teleported there. They had to be there. But nobody steps up to help the officers. The officers have to rely on what's in their computer at the time, their brain as they're processing it, of what's reasonable in the circumstances. There are people that are pointing toward the vehicle in the video as they go up. That becomes the most apparent threat to the officers at that point. That's the threat that's perceived at that point. Oliver takes a position to protect his partner, and the shots are fired. You'll hear Mr. Frederick's testimony is supposed to reign supreme. Grant did a good job with a video that's only 7.5 frames per second, maybe 15 frames. In that, though, Grant couldn't give you 2 things. He couldn't give you a speed analysis, which on direct, when they're bolstering up their expert, so they could do speed. You're missing velocity. We had velocity ready for them. Tell us the acceleration speed, because it doesn't help their case. doesn't help their argument, doesn't go through anything that's there. The speed itself is important to see how fast that vehicle was coming at folks. And it also couldn't justify what Officer Gross had already told you about 20 inches. As much as they want this vehicle to be far away from these officers, Officer Gross's reach is not superhuman. The vehicle got within 20 inches before it made contact with the glass. Before Gross stuck his arm out, I submit to you his arm had to go through and break the threshold at some point. That's a reasonable deduction from the evidence. So we know the vehicle's within 20 inches. And everybody told you, and the judges told you in this, you don't have to retreat. Officer Gross is trying to conduct a felony traffic stop at that point for a criminal offense that he's perceived. He has a right to be right where he's at. And Officer Oliver has a right to be backing his partner up right there. What's a reasonable belief from the evidence as Officer Oliver saw it? Not Gross, but Oliver at that point. All the interactions that have come up and worked through, nobody's told him anything other than pointing at that vehicle and saying, that's the threat. That's where we're at. Then we get to after the shots are fired, and we get to the last gentleman I think we heard on Friday afternoon, 2 Fridays ago, Mr. Mickens Sr. It's good to see he's not in his neck brace and back brace anymore. It seems like he's getting around pretty well. The problem that Mr. Mickens Sr. has is the evidence, Grant's evidence of State's Exhibit 8 and 10 don't bear out his testimony. And if you actually take the evidence, if the video is supposed to be such the important part of this case, and you apply it to what the witnesses actually said, most of the stuff doesn't bear out. It doesn't bear out. It looks like it's been coached or pitched to a certain degree. Mr. Mickens comes in and says, Roy was jumping up and down, pounding his feet, stomping after the shooting. Grant's evidence ends. You'll recall when Mr. Fredericks was here on cross, I asked him to scrub through some video and show you stuff. Those clips are on a thumb drive known as Defense Exhibit 14 if you want to take those 3 clips back to show you the last 3 witnesses on Friday afternoon. Mr. Mickens must have been mistaken at some point because Roy's not jumping up and down. The video's stable throughout. You can go back before the shooting 9 seconds and listen to what his feet sound like on the audio. It's all there for you. You can make a reasonable deduction from the evidence as we go through stuff. You can walk through it and understand what's going on. The video doesn't change. And that last clip for Mickens is to the point where his Tahoe is going through the nursing home parking lot. I'd submit to you that once he gets through the nursing home parking lot, he doesn't have the vantage point he testified about. So that's why we made those clips for you. But if we really want to know what's going on with Vidal in this case, the judge may have 30 seconds because this is your hand up.
Let me know when you're ready.
This is the definition we've been talking about. I've been talking about since I've been up. Officer Oliver has the right to defend himself, Officer Gross, and anyone else from apparent danger to the same extent as he would had the danger been real, provided Officer Oliver acted upon a reasonable apprehension of the danger as it appeared to him from his standpoint at that time. To view the reasonableness of Officer Oliver's actions solely from Officer Oliver's standpoint, from his vantage point. And you know they tried with that very expensive recreation. You know, that very expensive recreation, they spent probably more than a year's salary for most. Try to put that point of view right where Officer Oliver was at the time those shots were there. The data's just not there in the video. If you go back and look at those recreations for anything, remember, the vehicle was scanned separate. The wheels are never indicative of anything. And Officer Oliver told you what he was looking at. He wasn't looking at a manslaughter. He was looking at a homicide case because this was an intentional killing. He was trying to stop the threat. Vidal, when he testified up here, told you he didn't know who was yelling at him. If you go to Officer Chambly's case and walk through, Officer Chambly's in-car video brings you some very important stuff. It's the in-car, not the body-worn. The body-worn comes on later. The in-car's on during the takedown. You'll hear one channel of the stereo is Officer Chambly's body mic as he's performing the commands. Later on at 36 minutes, you'll hear from Vidal again. We talked about this when he was on the stand. The recording goes on. They didn't publish all of it to you. As part of the recording, you hear this.
Prior to
told the name, and you know, they moved out there on the car. And so they're all in the car. And then that's when we're pulling out. And then the men say, stop the car, stop the car. And I'm trying to pull the car and we can start flying. So they get a car block and I don't know, they go, I'm like, and so I look over, I'm like, oh crap, my brother stopped in my car. And so I was so nervous, I pressed the gas immediately, put that in action, and so after we were driving, 30 kids from the music to
He told you in the courtroom he didn't hear him say stop the car. And if you believe his testimony from the courtroom, he drove away from a person he never saw. He avoided a person he never saw. They knew there were officers out there. They knew who had the flashlights and who the flashing lights were. They made a decision not to stop. As tragic as that is, that put this to the point, the viewpoint of Officer Oliver to go through this. And I respectfully disagree with the state's position. They must have missed Dr. Kuntz's stuff, or Dr. Hayden from the board of directors from the same group that developed this technology and brings it to you today. The decision to fire takes a period of time. You have to back the vehicle up. Mr. Fredericks can tell you when he hears the shots on the video, but you got to back it up to when that decision was made. And that's what Dr. Kuntz brought you. Recognized science. If it wasn't, they would have 20 experts up here with the amount of money they've spent on Grant alone just to tell you that and refute it. But that's the facts of the case. If you don't believe that, listen to all the officers that have worked on the firing ranges where we've asked this. Begin firing and cease firing takes time. When you add the OODA loop to this in Dr. Kuntz, you come back to a position of where the vehicle was when it was justified to fire, when Officer Gross was still in the line of danger.
We'll recognize the Honorable Bob Gill and ask him if that's, Mr. Gill, ready to proceed with the morning, ladies and gentlemen. And I just have a few words for you about the court's jury charge that is going to guide your deliberations in this case. The jury charge contains all the law that you will need for your deliberations, all the law applicable to this case. We know from the oath that you took as jurors in the case that you're to base your oath on the law and the evidence as it came to you from that witness stand right there. And to go back to the jury selection a couple of months ago, one of the points I made sure everyone here understood was that there is no innocent verdict in this case. The jury's job is to find either the defendant not guilty, or in order to defeat that, you have to find beyond a reasonable doubt that he is guilty of any offense. Beyond a reasonable doubt means that the state has to remove 100% of the reasonable doubt from your individual mind. Has to remove 100% of your reasonable doubt before they're entitled to any verdict of guilty in this case. And there are several junctures along the way in this case that you have to make decisions. And it's all here in this jury charge. You have to decide if he's guilty of any offense. You have to decide if the justification applies. You have to decide if he was reckless. In each of those inquiries, the state has to prove to you beyond any reasonable doubt that they're entitled to that verdict. If they fail anywhere along the way, which they have, your verdict is to vote not guilty. There's no innocent verdict form. There's a not guilty verdict form. It's the last one on each of these three charges. And that's the verdict you ought to sign in each of these cases. The justification that you've heard about boils down to simply to a couple of things. People have a right to defend themselves against force by using force. If someone comes at me with hands and fists, I can defend myself with hands and fists. If someone comes at me with a knife, I can use a firearm to defend myself. If someone comes at me with a vehicle, I can use a firearm to defend myself. I don't have to retreat if I'm lawfully where I was at the time. Same with a third person. If I see a third person in danger, and it's immediately necessary for me to use deadly force to counteract the deadly force that they're being threatened with, I can do that. The law recognizes that we have a right to defend ourselves and other people. And before you can find someone in that situation guilty of any criminal offense, the state has to prove beyond any reasonable doubt that that person defending was not reasonable. It's that simple. The judge goes on to tell you in the jury charge, on page 11 I believe it is, that there is certain evidence, and Miles alluded to that a few minutes ago, there's certain evidence in this case brought to you about different courses of conduct, different instances. And a couple of things about that. Number one, none of those things were admissible as to the guilt of Mr. Oliver. They were only admissible for the limited purpose of showing his state of mind, if any, if you believe those things beyond a reasonable doubt. If you have questions about them, you can't even consider them. And you shouldn't, because of the way this testimony came into you. But you can't consider it unless you believe it beyond a reasonable doubt, and then only for his state of mind. But the best evidence of Roy Oliver's state of mind on April the 29th of 2017 is the body-worn camera footage that the state introduced the first day of this trial. The body-worn camera footage shows Roy Oliver and Tyler Gross coming up on a house full of kids. They didn't find the situation they were dispatched to. They didn't find any drunk kids. They found a bunch of kids having a good time. And Roy Oliver and Tyler Gross were having a good time breaking that thing up and sending these kids on their way. Joking with the kids, doing their duties, looking around the house to make sure there weren't any drugs or alcohol or hurt or intoxicated kids there they needed to deal with. Everything was fine. Everybody's going on their way. And all of a sudden, things changed 180 degrees. And this jury charge tells you that you have to look at things under the same circumstances as Roy Oliver did when you're judging his actions on April the 29th of 2017. You have to look at things, a reasonable belief means things that Roy Oliver would have known under those circumstances as they existed at the time. So you have to take yourselves and strap on Roy Oliver's boots. And you have to go out and put on a Bald Springs police officer's uniform and get in that Chevy Tahoe and drive out to 12304 Barron Drive on April the 29th of 2017. And you have to know in your mind everything Roy Oliver knew at that time. His training, his experience, the knowledge he had about what was going on in that neighborhood at the time. You got to walk into that party and turn your body-worn camera on so that there's a record of what went on out there, just like he's supposed to do. You have to begin breaking that party up, doing your duty. You have to have in your mind that you're there to protect the public, but most of all, your foremost duty is to your partner. You heard the testimony from every law enforcement and ex-law enforcement officer that testified here. The paramount duty of a police officer is to make sure his partner goes home at the end of the shift. They protect their buddy, they protect their partner. And that's what Roy Oliver did that night. When you heard shots fired, you've got to recognize that as being what it was. It was automatic, semi-automatic weapon fire from a deadly weapon, more than likely, more than one deadly weapon. And you've got to do what Roy Oliver did. He sees his partner go one way. He went back to his vehicle and got his city-issued patrol rifle because he knew he had an active shooter he had to deal with. And he started walking up that street. And in his training and in his experience, the things he saw and heard going up that street added to his basis of knowledge of what he was dealing with that evening. He saw a car that wasn't stopping. He saw his partner walking after that car. He heard his partner telling that car to stop. He heard the change in his partner's voice. He saw his partner draw his sidearm. He knew from his training and experience that his partner wouldn't do that unless he was dealing with a significant threat that required him to be armed and ready with deadly force. And as Roy Oliver was walking up that street, he heard Tyler's voice change. He knew that weapon was out, and he knew he'd better hurry. And he got up to the top of that street, and he saw that vehicle sitting up there in that cattywampus position, pointed towards Tyler Gross. And in that split second, he made the decision he had to make. And from that, we have to take away all those things we know now that we didn't know then. We didn't know who was in that car. We didn't know that that car was not connected with the gunshots that went off out there. All the information they had was that it was. It was the one that was leaving and not following the commands. It's like Tyler Gross told you from this witness stand right here. He said, I know now that the wheels of that car turned, but I didn't know that until we slowed down that video. The wheels of the car turned, but I didn't know that until we slowed down that video. So even Tyler Gross has been influenced by what he knows now. But you can't let that get into your minds, ladies and gentlemen. You have to put your mind frame in what Tyler Gross and Roy Oliver knew at that time. And remember that Tyler Gross told you from this witness stand right here. He said, he definitely came at me, which is why I punched the window. He definitely came at me, which is why I punched the window. That was one of the first responses to questions when we got him away from Mr. Snipes on cross-examination. He definitely came at me. That's why I punched the window. Remember what he also said? That vehicle accelerated and it went by me very fast. Roy Oliver shot at the same time I broke that window. That vehicle was pointed at Tyler Gross, and it was a threat to Tyler Gross, and that is why Roy Oliver reasonably made the decision that he had to make. He got put in that position not by his own actions, but by a combination in a confluence of events out there that night. We can't look at anything in a vacuum. We can't look at anything by itself. Everything has to be looked at together. And when it's all looked at together, we see why this happened. It doesn't matter that looking back on it in hindsight, we all make a different decision now. We have to look at it how Roy Oliver saw it at the time. And what he saw was a significant threat to his partner. We can look at it back at it now and think, Roy wasn't even right. It doesn't matter. Roy has a right to defend Tyler Gross against a perceived danger, against an apparent danger, even if it wasn't a real danger, as long as that's what he reasonably believed at the time he made the decision. And before you can find against Roy Oliver on that issue, the state has to prove beyond any reasonable doubt that he was not reasonable on that occasion. And it can't be done. Because looking at it from his standpoint at the time, he made the reasonable decision he unfortunately had to make. Ladies and gentlemen, Roy Oliver should be found not guilty. Thank you.
Thank you, Mr. Gill. The court will recognize the Honorable Jim Lane on behalf of Mr. Oliver. Mr. Lane, you have 12 minutes until your 2-minute warning. You may proceed whenever you're ready.
Judge, I won't take too long, but I do want to do something that I often do, and that's to thank the judge, the court reporter, these wonderful men and women in uniform that have been here with us for the last 3 weeks, basically. This is their job, and this defense team is from out of town. You always worry a little bit about when you're out of town what you're going to get yourself into. And Judge Birmingham has run this court with great precision, and he has made difficult decisions. Lawyers don't always agree. If we all agreed on everything, we wouldn't be here. But I wanted to make sure you understood that court reporters like Perry try to keep up with lawyers that are all talking at the same time. I want to take a minute and let's talk about, Roy, stand up. Come over here, stand up. I want to take a minute and talk about the defendant, the accused. Well, those are great words, but we're really talking about Roy Oliver. And who is Roy Oliver? When I first met Roy Oliver and I learned about him, I thought of him as a protector. And why would I think that? Well, if you listen to him talk about his mother and what he did as a child with a single mother trying to raise a boy under difficult times, he did his part. He was a protector. And then when he was old enough, he wanted to be a firefighter. Now, I don't know about y'all, but I've often wondered about firefighters who run into the fire when everybody else is running out of the fire. He wanted to be a protector. He really wanted to be a firefighter. But eventually, he decided he would join the Army. Now, you saw Dr. Hayden, and bless his heart, we who experienced Vietnam know exactly how he feels. And that's why I always tell my son, Jake, welcome him home. Because there were no parades, there were no people at the airport, there were no video cameras waiting to get your reaction. There was no one. It was the thankless war. Roy Oliver, at a time when this nation said, volunteers, we want volunteers. And where are you going to go? You're going to go to Afghanistan or Iraq. So volunteer, be an 11 Bravo, grunt. What did he do? He went down and joined to be a protector. And what did you find out about his first tour? He was a guy on a striker, and very difficult decisions had to be made. And when they ran into a difficult situation, his job was to get off of the striker and go forward. See what it was all about. Try to warn everybody in the striker. And he was successful at that. Did all of your troops come home, Roy? They all came home. Comes home, and in a period of time, a first sergeant major says, you're going to go back. Your re-up's going to go back to Iraq. But this time you're going to go back in a personal security detail with a colonel. And you're going to be with him every minute of the day. So what does he do? He says, okay. And what does he do? He does his job. And he brings that colonel home. What did he do? He fulfilled his mission. He protected the people, and especially the man he was charged with. So what does he do then? He wants to be a police officer. That's not uncommon for guys coming out of the military. They make excellent police officers. And he becomes a police officer at Ball Springs. And you know that he was a street cop. But there's another side of Roy too. He's a dad. He has 2 children. He's married to a girl from South America. He's doing that job every day. And I was kind of amazed at one of the DAs that came here to testify when he said, officers are trained to do a 12-hour shift, come down here and spend 12 hours with us, go back on their shift. They're trained to do that. Nonsense. They're not either. They're not either. You don't put officers out on the street if they're not capable of performing their duty with their best ability. You have to be able to think. You have to be able to react. I thought that was kind of strange, kind of a cold decision about police officers. And we know what Roy told us. He said, my impression was that they thought officer safety wasn't important. That says a lot to me, officer safety. So let's think just for a moment, and you've heard great arguments, and my friend Mike Snipes will finish this, and he will I always said with the fervor of a Baptist preacher on a Saturday night at a revival, we'll talk to you. But the reality is that this case boils down to a shoot or no shoot situation. And we brought you an expert named Captain Coons. Now, you can tell by the way I look, this is probably not my first time to do this. And I listened very carefully to Dr. Hayden, and I realized, he's a great guy. He's a smart guy. But he's never been a street cop. He's never shot anybody. And the last time he arrested anyone was 1983. The rest of his time has been training. Well, that's great. Training FBI agents. And I walked him through the entire 9 seconds. Good community policing. Excellent work. Excellent, excellent. Taking the weapon out, going up the street. Good position? No, not the best, because they were exposed, both of them were. And Dr. Hayden, did you, in your mind, think in terms of an active shooter? We all know about active shooters. Lord, we had one this weekend. Active shooters. What does that mean? That means somebody's up here shooting indiscriminately at people. And what do these two cops do, these two street cops? Instead of running from it, they run towards it. They have a real problem on their hands. They've sent all these kids out. So not only do we have an active shooter, we have kids, young adults, in the streets. And what happens when that shooting starts? They're all coming this way. What do these two cops do? Right towards it. I went through everything with Hayden up until I said, Hayden, can you clap your hands as fast as this decision was made? No, I can't. I can't do it. I asked Dr. Coons the same things. He agreed with Hayden. But the difference was, he's a street cop. He's been through 3 shootings. He did the education for you, the OODA loop, and you can take that back there. Dr. Hayden, do you agree with force science? Oh yes, oh yes. Captain Coons, educate us. What does it mean? How does it work? It's fascinating. But it's a science and it's real. It's how it works. It's how we work as humans. That fast. That young man right there had to make that decision. Was it reasonable? Dr. Hayden? No. Was it reasonable? Captain? Yes. Yes. Considering all the facts and what they knew at that time. Dr. Hayden, how do we look at it? Well, you have to look at it from the standpoint of the officer, taking into consideration his training and experience and the moving situation that he was in. Does it have to be a perfect decision? No. Does he have to be absolutely right? No. It has to be reasonable. And Lord, help us if we can't look at what these officers do that are reasonable. So, we worked hard. Everybody has in this courtroom. I never thank juries for serving. It's your duty. It's the only way this system works. It's the greatest system of justice in the world. I will thank you for your time and your attention. You've been great. But when you look at this from a reasonable standpoint, you can't put aside what we all find now. Lord, do we have sympathy for that family? That was the first thing this defense team said. Ms. Edwards, we offer you and your family our deepest sympathy. But the charge says sympathy doesn't play a part in this. The facts do. And not the facts that we know now, and not the facts that we should have known, because we know exactly what these officers knew. We have to look at it from the eyes of that officer the moment he made that decision. I'm going to ask you to find this young man, this soldier, this cop, this family man not guilty.